Welcome to today's video. We're going to be watching some true crime on the channel today. If you're watching this on YouTube, you missed the Twitch stream, but that's okay. You can follow the Twitch stream and watch whenever and whatever. I don't always do true crime, but I stream almost every day. If you're watching this on YouTube as well, consider subscribing. That would be really awesome. It's good to know that people like seeing this sort of stuff from me. And a lot of these videos are from the React suggestions of Discord, of my Discord. So consider joining the Discord in order to suggest some videos to watch. You know what I mean? Let's watch something else. Let's watch an audit the court video. Cop arrests firefighter, then tries to claim qualified immunity. We love audit the court. They do a decent job of explaining things, especially within the court and the legal system itself. I don't think we've seen one of these in a while, so I'm excited for it. Yep.
On February 4th, 2014, Officer Eleazar Kolunga of the California Highway Patrol responded to a call regarding an overturned vehicle. An ambulance and multiple fire trucks also arrived on the scene, including a fire truck driven by fire engineer and EMT Jacob.
By the way, I'm sure he's going to explain this just to show that I know what I'm talking about. Qualified immunity means that, like, they're absolved of whatever crime they committed in that moment because they had, like, a good reason, essentially. I mean, it's a lot more complicated, but that's what people basically take away from it.
Gregoire of the Chula Vista Fire Department. Two of the fire trucks left at Officer Kolunga's request, and he asked the two remaining fire crews to move their trucks into the center median. When the fire crews did not move their trucks, Officer Kolunga requested that they move them again. At the same time, Officer Sergio Flores, also of the California Highway Patrol, arrived at the scene. After identifying Mr. Gregoire as the driver of the fire engine, Officer Flores engaged him in a discussion about moving the fire truck, ultimately arresting him for his failure to move the truck. Officer Flores handcuffed Mr. Gregoire and held him in the back of his patrol vehicle for approximately 30 minutes before he was released, with no criminal charges being pursued against him. On June 12, 2014, Mr. Gregoire filed a civil lawsuit against Officer Flores and the California Highway Patrol in the San Diego Superior Court, claiming federal civil rights violations and several state law causes of action. The case was subsequently removed to the federal United States District Court for the Southern District of California on July 25th, 2014. On November 23rd, 2015, Officer Flores and the California Highway Patrol filed a so-called motion for summary judgment on all of the claims against them, which, as Rule 56 of the Federal Rules of Civil Procedure explains, is a request that the judge decide the claim as a matter of law without a trial because there is no genuine dispute of material fact. In the motion, Officer Flores argued
they're basically telling the judge to throw it out.
That he was entitled to so-called qualified immunity, which is a legal doctrine that protects a police officer from being held personally liable for their violation of an individual's constitutional rights when the law is determined to not have been, quote-unquote, clearly established at the time of the infringement. On February 16th, 2016, after briefing by both parties, U.S. District Judge Gonzalo Curiel determined that Officer Flores was not entitled to qualified immunity for his actions and denied the motion for summary judgment for all causes of action, except intentional infliction of emotional distress. Officer Flores responded by filing a so-called interlocutory appeal to the Ninth Circuit Court of Appeals, which has jurisdiction over California federal courts, seeking immediate review of the denial of qualified immunity. The Ninth Circuit docketed Officer Flores' interlocutory appeal, and the case was scheduled for oral argument on December 6, 2017, before Judge Ronald Gould, Judge Kim Wardlow, and Judge Rainer Collins.
What's up, Dad?
During the oral argument, Officer Flores was represented by Deputy Attorney General Robert Rogoyski of the California Attorney General's Office, and Mr. Gregoire was represented by Attorney Jeremy Robinson. Now, since Officer Flores was the party who initiated the appeal, Mr. Rogoyski presented his oral argument first.
Deputy Attorney General Robert Rogoyski from the California Attorney General's Office, here on behalf of defendants, appellants, California Highway Patrol, and Officer Sergio Flores. I'd like to reserve, if I may, 3 minutes of my time for rebuttal.
All right, watch the clock.
May it please the court. This is a qualified immunity case, and the court should find that the doctrine of qualified immunity applies to both of the federal claims in this action. I'm going to start today by talking about the arrest claim, and then I'll move on to the excessive force claim, and then if there's any time remaining, I'll address the issue of jurisdiction over the state law claims. So starting first with the question of qualified immunity for the arrest. There are three independent reasons why.
No, he doesn't have only 3 minutes. He's reserving 3 of his minutes to rebuttal the other side's talk, argument, whatever. My computer keeps dinging. I'm sorry.
This court can reverse.
I need to turn that off.
But the most straightforward is the second prong of the qualified immunity test. Here we have two competing interests. On the part of the fire department and plaintiff Gregoire, there was an interest in management of the scene in terms of taking care of the patients who are present on the scene. That's their perspective. From CHP's perspective, there's a very important competing interest in protecting passing motorists who are going by a freeway that's partially blocked by fire engines and by a squad car and by an ambulance from subsequent accidents, being injured or being killed on a busy freeway at night. So we have these two competing
What? We have what?
So we have these two competing interests. And against that, we have a set of state statutes that don't explain what consultation means.
Hitting the 6-7 in 2017. Wow.
And they don't explain which of these competing interests predominates.
Well, doesn't that case, the County of San Bernardino versus City of San Bernardino, kind of outline who's in charge of what in terms of emergency scene operations?
Yes, and the statutes give a general outline.
Clear that
once again, an important piece of qualified immunity is the argument that the laws are not clearly defined for the situation you're arguing for. This is her literally being like, aren't there literally defined rules because of quoting case from the past that is giving said rules?
the police are in charge of the scene management, but medical personnel are in charge of patient care decisions, right?
Yes, but the specific provision at issue there comes down to Health and Safety Code 1798.6, which says that priority goes to persons exposed to the most serious risk. It doesn't say how you figure that out. Is the most serious risk the patients who are on the ground, who were recovering from the accident?
Mr. Rogoyski and Judge Wardlow discussed the California statutes that pertain to the management of the scene of the accident. Section 409.3 of the California Penal Code provides that whenever law enforcement officers and emergency medical technicians are at the scene of an accident, management of the scene belongs to the appropriate law enforcement agency, whose representative is required to consult with representatives of other response agencies at the scene to ensure that all appropriate resources are properly utilized. The statute further provides that authority for patient care management is governed by Section 1798.6 of the California Health and Safety Code, which places authority over patient care at the scene of an emergency in the hands of the most medically qualified, licensed, or certified healthcare professional at the scene, and requires that the scene be managed in a manner designed to minimize the risk of death or health impairment to the patient, with priority given to the interests of those exposed to the most serious and immediate risks to life and health.
This is why not just police respond to an emergency situation, by the way, in order to distribute what might need to be done correctly, you know?
In the 1997 case of County of San Bernardino v. City of San Bernardino, the Supreme Court of California clarified that the term management of the scene, as used in Section 1798.6, refers to non-medical management, giving authority to law enforcement personnel for functions such as excluding bystanders and rerouting traffic, while responsibility for patient health care is assigned to medical personnel. It is precisely this division of authority between law enforcement and medical personnel at an accident scene that lies at the heart of the dispute between Officer Flores and Mr. Gregoire.
This is a case of disputed facts, and I realize that the parties have different stories, but suppose we take this and look at the facts in the light most favorable to Gregoire, the non-moving party. and his witnesses, they all seem to say that he was actually attending physically to a patient when he was arrested by Flores.
Yes, but it is also undisputed that, in the words of the lower court, that Officer Flores faced concern about secondary accidents, and there are undisputed facts which establish that Officer Flores talked to the firefighters and Officer Colunga talked to the firefighters, which Officer Flores overheard. So this court takes plaintiff's version.
Are you aware of any other case where at the scene of an emergency, a police officer arrested someone who's attending to someone medically?
I'm not aware of a reported case.
Doesn't really happen,
and
nor
for that
should
reason
it.
alone, the second prong of the qualified immunity test applies here. There have been situations, I believe factually, I'm not sure this is in the record.
Don't tell us things outside the record. I'm just saying, have you ever seen, is there
Also,
any other case?
weirdly a good point to argue that like there isn't a case, so that does sort of bring up what the purpose of qualified immunity usually is for. That is weirdly a good argument. I will say that.
That, is out there.
We're not aware of any case that has addressed a situation even remotely like this, Your Honor. And for that reason alone, that's a simple reason why the qualified immunity test,
very
the
interesting,
second prong of the qualified immunity test to apply here.
Or it could be that it's just such an outrageous thing to do.
Also a great argument.
So
it is
Your Honor
pretty
refers
ridiculous.
to the obviousness exception to qualified immunity. This court has recently defined obviousness as conduct so flagrantly unlawful that few dare its attempt.
He arrested a firefighter attending to an injured person. I would say that's pretty ridiculous.
Case defies obviousness because we have a state statute which contains an inherent contradiction. When you have an EMT who's engaging in their duties, and that EMT is arguably in conflict with a CHP officer engaging in their duties, who wins? We don't know. The California state statutes don't explain that. We're not aware of any case law that explains that. So it's hard to say that this is so flagrantly unlawful because there's no explanation for what qualifies as unlawful.
Were there ever charges brought against Grigor?
No, there were no charges brought against Mr. Gregoire.
Mr. Rogoyski argues that because there is no existing case law that discusses a similar situation, Officer Flores should be granted qualified immunity under the so-called second prong of the qualified immunity analysis. The two-prong qualified immunity test, which was formalized by the Supreme Court in the 2001 case of Saucier v. Katz, establishes that a government official, such as a police officer, is entitled to qualified immunity unless the plaintiff demonstrates that the official violated a constitutional right, which is considered the first prong of the test, and that the right was clearly established at the time of the conduct, which is the second prong of the test. Although the Supreme Court originally held in the Saucier case that a court must address the prongs in order, in the 2009 case of Pearson v. Callahan, the court revised the test to allow the courts to address either prong first. In other words, courts may decide that qualified immunity is warranted based solely on the fact that the law was not, quote-unquote, clearly established at the time of the alleged violation.
That's what I was saying. It's unfortunately in this situation a weirdly good argument because he is technically correct in the sense that there isn't, based on what he's presenting and saying, what the judge is also saying, there isn't something legally binding the situation to a similar one. So weirdly enough, qualified immunity is sort of a decent argument here because it's like there's nothing to go off of, which is the whole reason qualified immunity exists, because it's like, well, the fuck was I supposed to do? Nobody knows. Very strange.
Without determining whether or not the underlying conduct was constitutional. Additionally, in the 1987 case of Anderson v. Creighton, the Supreme Court held that for a right to be clearly established, it must be defined with sufficient specificity, such that a reasonable official would understand that what he is doing violates that right, rather than established only at a high level of generality. Well, under this framework, Mr. Rogoyski's argument is that even if Officer Flores violated Mr. Gregoire's constitutional rights, no prior case law had addressed a situation sufficiently similar to the circumstances at this accident scene, and therefore, a reasonable officer in Officer Flores's position would not have known that his conduct was unlawful, entitling him to qualified immunity on that basis alone.
So going back to the obviousness question very, very quickly, if there were a definition of consultation and there were case law on that, particular case law from the circuit, then we might get into an obviousness zone. Or if there were obviousness is usually applied in excessive force cases involving extreme examples of excessive force. That's just not the
weirdly a good argument
that we have here. And it is an open question whose interest predominates if you have a patient on the ground and someone attending to them, and a concern, which is undisputed and recognized by the lower court, that the next person's going to ram into the back of one of these vehicles that's blocking the freeway and get injured or killed. You know, who gets priority? We don't know. CHP doesn't know, firefighters don't know, and that's why they're supposed to consult about it. But we don't have a definition of consult either. So how does that get figured out? When we have all of these questions, which cannot be answered.
Consult doesn't mean arrest.
I agree with that.
Also true.
One regular definition of consult is to seek information or advice from. That's a pretty plain language definition of consult. If you use that definition, that's what happened. Officer Colunga went and talked to the firefighters, asked them to move their trucks. They didn't. He asked them, why are you not moving them? They gave their explanation. Under that plain language definition, consultation would have happened within the meaning of the statute. But we don't even have that here. We don't know if that's good enough or not. And a CHP officer in a developing situation on the ground who has to make some quick decisions in the interest of public safety needs to have some discretion to make a decision that we might afterwards say was not prudential. That's what qualified immunity does. It protects their discretion in these rapidly evolving situations.
I weirdly don't hate the argument. I'm not even, like, he's not even arguing whether he's correct or not. I mean, like, it's a decent way to go about it. Like, he's not saying that he's in the right. He's saying that the laws aren't good enough to explain what he was supposed to do. That, I mean, like, once again, that is qualified immunity, where it's like not benefit of the doubt, but discretion, where it's like in situations cops might have to do stuff just because there's not time to really like break it all down and think. Obviously that can come with, like, you know, abusing it. But there's plenty of situations where, like, somebody doesn't do something correctly, but there wasn't like a good way to the laws at the time don't provide an adequate answer for what is the procedure. That is a great synopsis of his argument, essentially. I mean, that's exactly it. Is there's not a good, like, I mean, to him in his argument is, it's like the cop isn't necessarily right for doing so, but there wasn't anything adequately telling him what he was meant to do. So, like, we could sort of argue that we don't have to really go after him for this.
And sometimes in the application,
or we shouldn't, rather, is what he's saying.
That may not have been the most advisable thing
motioning
to do.
to dismiss it.
But again, 2020 hindsight doesn't apply to the situation here.
So Colunga went and talked to the firefighters, but Flores didn't.
Well, Flores also spoke to Mr. Gregoire, but it's undisputed that he further overheard Colunga speaking to the firefighters and specifically asking them, you know, hey, why have you not yet moved these fire trucks?
And the explanation was?
The explanation was that they were engaged in patient care, although I don't think that's technically part of the record. I think it can be inferred that it's part of the record.
And that's certainly what Gregoire says, right?
Well, it's from witness testimony.
And it's two witnesses.
Yes. And that is plaintiff's version of the facts. But it's also undisputed that California Highway Patrol had a competing interest in protecting passing motorists from getting into a severe accident.
Why didn't they just get the keys and move the fire truck?
So that's a good question. It turns out the only person who was qualified to move the fire truck, and no one found this out until after the arrest happened, was Mr. Gregoire. Captain Albright himself later said, I believe, around the same time, that he was not qualified to move the fire truck.
Seems like there's well, I don't want to go into it, but anyway, go on. How much time did you want to save?
What?
Okay, Judge Gold.
I have a question for.
Oh, fuck. Guys. guys, show about like benefit of the doubt and intention, you know what I mean? Like, I thought this guy was making I thought they just like took a weird picture of this guy when they posted it earlier, but that's just his posture because he's clearly got some sort of physical ailment. And I apologize because that wasn't my intention to make fun of his ailment. I just thought the video took a bad screen grab. All right, that's it. I'm grifting. Just kidding. All right. My fault.
Counsel, if I may. Let's put the arrest aside for a moment and let's say I assume that there's not clearly established law and someone's got to be the captain in that situation, and so the plaintiff loses. Still, how can it be justified on the excessive force claim for police to put like an EMT in handcuffs, which also were alleged to be two types? I mean, as I looked at this,
it's a great point.
Like an unusual case of two good guys getting in a dispute.
It's a great. Who the fuck arrests an EMT on the scene? It's once again, I can't argue that the lawyer's making a bad point. Like, he's making a good point, but also like, who the fuck arrests an EMT officer who's like in the middle of helping somebody? You just wouldn't, because that's ridiculous.
A cop, not an EMT. But if the dispute required an arrest, why did the police put the EMT Gregoire into cuffs?
So again, we're getting to the distinction between what is within the scope of discretion and what is prudential. Looking back at the situation, we may say it was not prudential or advisable to put a firefighter into handcuffs. But it is standard practice everywhere during the course of an arrest to place the person in handcuffs. Officer Flores did not know at the time whether this individual he was placing under arrest would behave like a normal individual under arrest or would respond with a substantial amount of adrenaline. So he did the standard procedure, which is to place that person in handcuffs. As to the tightening of the handcuffs,
he's an EMT or a firefighter. That's
from the second prong of the question.
You need to be. It's both. A lot or both. It's like, I can't remember exactly what it is. It's either you need to be an EMT to be a firefighter, or a firefighter to be an EMT. I don't remember which exactly it is. Somebody might be able to clarify that. I don't remember which is which. EMT to be firefighter, right? So that, I mean, it applies either way. Well, that makes sense, because it's like, you know, firefighters go on scenes of pretty big crises, especially if the fire is bad, and fire typically injures people pretty bad. So you probably would need emergency medical training in order to, you know, further help improve the situation. So that, I mean, that would make sense. But yeah, I mean, when they're saying EMT, they're saying firefighter as well. Like, it's both.
Qualified immunity test. We don't have a case on point which deals with this specific situation, which is, we have to remember two important facts. One is that there was no physical injury. It's undisputed that Gregoire was not harmed. He didn't have any bruises, nothing. The other fact that's important to recognize here is plaintiff says he asked for the handcuffs to be tightened and or he asked for them to be loosened, and they were just tightened. That's actually not what the record shows. One of the pages cited by plaintiff, record at 93, is an admission by plaintiff where he asked for them to be loosened, then they were locked, which had the effect of making them tighter. So we have these two interesting features: handcuffs requested to be loosened, but which were tightened to a point short of causing injury, and plaintiff admits they were locked, which is a procedure to prevent them from causing injury. Is it beyond debate that every single reasonable officer would know that you can't do that based on existing law? No. And in fact, there are some situations where a reasonable officer might think that handcuffs, which can be tightened to some point short of causing injury, should be tightened. So again, we don't have a case on point. And this is one of those areas where it might not be advisable to have a case on point, because we're dealing with excessive force in the sense of the minimum amount for excessive force you need to have a viable claim, not an extreme case of an excessive force like a shooting or something like that. And we're getting very close to traipsing all over the legitimate scope of officer discretion. And we want to avoid a situation where the manual of handcuffing procedure was written entirely by the judiciary. So as a prudential matter here, when there's no injury, when we have no cases which are on all fours, all threes, all twos with this, then the safest thing to do is say the second prong of the qualified immunity test applies.
And counsel, is there evidence in the record supporting the point you made in response to my question, saying that all officers put people in handcuffs whenever they make an arrest?
I believe that's there isn't evidence in the record that I'm aware of that I can cite offhand, but I believe that is a well-recognized principle in this circuit's jurisprudence, and I believe it's in the statement also.
I mean, that's true. I mean, if somebody got arrested, I would probably also assume they were in handcuffs too. Yeah.
Also appears in one of the cited cases. I think it's Lowand. I'm blanking on the specific case site. I'm under 3 minutes, so I would like to reserve the rein of my time for rebuttal, if I may.
You may.
Thank you.
Mr. Rogoyski completed his argument on behalf of Officer Flores, reserving the rest of his time for so-called rebuttal, which is an opportunity to respond after the opposing party completes their argument. Mr. Robinson then took the podium to present his oral argument on behalf of Mr. Gregoire.
Good morning, Your Honors. Judge Gould. My name is Jeremy Robinson. I represent the appellee, Jacob Gregoire, in this case. Your Honors, you had mentioned at the beginning of my colleague's argument that this is a case involving a lot of disputed facts, and I think that's one of the key things that needs to be kept in mind when looking at the district court's ruling here. One of the problems, I believe, with the CHP's argument is that it tends to flow from their version of what they think happened, and they then take that and say, well, under our version of these facts, we're entitled to qualified immunity. But, of course, the opposite is what you're actually supposed to do at this stage. And so you have to start from the premise that we're working from Mr. Gregoire's version of the facts.
My understanding of this is that Officer Flores could still be entitled to qualified immunity depending on what facts are found by the jury.
If I'm understanding your question correctly, it is possible, yes, that the case could be tried to the jury, and depending on what factual findings the jury makes, Officer Flores could be entitled to qualified immunity. But it's also possible that the jury could make a finding of fact where he would not be entitled to qualified immunity, right, which is why the summary judgment was denied.
Well, that's why you go to court.
Correct. Yes, that's exactly true. So I think, you know, the legal issue that they've raised relates to the clearly established part of the qualified immunity analysis. And this, it was just sort of mentioned in passing in the district court. It wasn't really even made an issue there, but they've made it an issue on this appeal. So I wanted to address that.
The fuck was that? Did somebody fart?
Really even made an issue there, but they've made it an issue on this appeal. So I wanted to address that part of it. But I do think because the law and the Supreme Court has continually told us that we have to look at the specific factual parameters and not just sort of a broad brush of what happened, it's important to get a few facts out there from Mr. Gregoire's perspective. The first being that he was, by his admission and by several other people's admission, engaged in patient care at the time that this happened. Mr. Flores, Officer Flores, and maybe Officer Colunga say that they didn't see that, but we take that as true for the purpose of this particular situation. In addition, Officer Flores had placed a flare pattern behind his car, which he had parked behind the fire trucks and the ambulance on the freeway. So he had already established a protective zone behind these to eliminate or at least minimize the risk that someone was going to crash into the back of the fire trucks. And there was some dispute about whether the ambulance was in the freeway or not in the freeway, but again, Captain Albright says that he believes that it was. We take that as accepted at this time. So one of the critical components, which my colleague mentioned, is he believed there was some level of consultation between Officer Colunga and maybe to a lesser extent Officer Flores and the fire department. But the record does not reflect that unless you consider consultation to be, I command you to move your truck. That's essentially the level of consultation that there was. If
that's
you look
not
at
consultation, though, that's commandment.
Declaration, and that's
commanding or declaration. That's not consulting. That's the person who's assuming they're in charge commanding, not the person who's supposed to be underneath consulting.
That's page 180 of the excerpts of record.
How have they not thrown the cops case out at this point? This is not the cops case. This is the EMT's case. So this happened in 2014 and he's civilly suing them in 2017. The cop's lawyer this is a motion to dismiss the case based on qualified immunity. So they're not asking to throw out the case. Well, they're asking to throw out the case, but it's not the cop's case. They're asking to throw out the case so the cop isn't sued civilly. Does that make sense?
And I'm looking at page 183. He said, I had conversations with members of the other two fire crews to ask them to move their trucks into the center median. That's the extent of the consultation. I mean, I know my colleague said he maybe asked them why they didn't move their trucks, and there was some colloquy about that.
Sound like a whole lot of
there's no record of that. That's not part of our record on appeal here. Essentially, what we
Counsel,
yes,
Judge Gould, if I could ask you a question.
Yes.
Along the lines of what I asked your friend on the other side of the case, is there any authority pre-existing, some case law, that says that if we have the situation where one, I'll call him a good guy, an EMT is doing some medical care at an accident, but a police officer, a second good guy.
Can someone explain why they wanted to move the truck? It was because they were on the highway. There was an accident on the highway and the cop needed them to move the car, the fire truck, because the argument is that they were worried the truck was in the middle of the highway and that they were going to get in an accident and causing further damage. What loses me is apparently the cop threw out flares to signify a zone, which typically people don't just drive over flares. They go, oh shit. So that, yeah, I don't know.
Is on the scene and has to try to keep traffic lanes open for purposes of avoiding another accident. Is there any law that says in those circumstances the police officer has to defer to the EMT if the EMT's working on a patient?
There is no case on point on that. I think both sides will agree to that point. What our position is that the statutes themselves are clear and unambiguous in this particular fact pattern. Again, when you're looking at the facts as they are construed in most favorable terms to Mr. Gregoire, because the statutes do require, they say shall consult, they require some level of consultation by the CHP or whoever's in charge with the emergency medical technicians before making some decisions that affect patient care. So there may be some gray areas out there where there was a consultation and there was some disagreement between the people about whether who gets priority, things of that sort. I can see there may be some circumstances, but I don't think this is one of them because there wasn't any consultation. So if you just look at the terms of the statutes themselves, they're not ambiguous on that point. And I don't think you need a case to have addressed that particular circumstance to understand the statutes.
So the statutes are clear and ambiguous at once? Well, that's part of his argument, is that, like, he's agreeing that the point the other guy made up or brought up is ambiguous, but he's saying that the remainder of it isn't. So, like, there's that level of obviousness that was brought up earlier where it's like, you can't just be like, well, one piece of this isn't clear, therefore I don't know what to do. Like, he didn't disagree that the point he's bringing up isn't unclear. What his argument is that, like, the rest of it is. So, like, what the fuck what are you talking about? Like, they clearly did follow procedures based on what we're told, and there's a level of understanding that he operated at. So, like, why is this one specific piece you're arguing for? Like, that's, the vagueness of it doesn't really make sense, or doesn't really qualify for, or doesn't really count for qualified immunity, because the rest of it, he operated under, under what is this, what we're seeing as, like, an understanding of what he was meant to do, because that's what he did.
And I should point out, Officer Flores himself references these statutes as a basis for making his arrest. So there's no claim that he was mistaken about the law, or he didn't understand, or that they weren't clear and he wasn't sure exactly what he was supposed to be doing.
So your case rests on the shall consult, and your version of the fact is that he didn't consult, and that's a clear mandatory duty under the statute. And the defense is that he did consult. So that's what the battle is going to be about at trial?
That's certainly a big part of it. I mean, I can't speak for them for their defense, but that appears to be the position they're taking. Their briefs suggest that they believe he did what was required under the statute by way of some form of consultation.
Is there any definition of consult, or we just look at the ordinary meaning of consult?
In this case, I think you can look at the ordinary meaning of consult, and in fact, I would be happy to accept their definition of it, because he defined it as requesting information from, or talking, getting information from. And again, if you look at the facts, the declarations, there was no exchange of information with Officer Kalunga. He didn't say, okay, I have this concern. I understand you all are taking care of patients, but I'm also worried about this other circumstance. We need to work this out. Let's try to figure out what's the best thing to do.
They could have probably had someone else attend to the patient while Gregor moved the truck, if that was...
Probably, yes.
Other firefighters there, right?
Yes, there were other firefighters there. And
other EMTs there?
Yeah, but I think they also said that, like, it wasn't established until afterwards that only he could move the car. Like, they literally brought up that it wasn't known until after he was even arrested that he was the only one capable of moving the car anyway.
Other paramedics there, yes. So sure, they could have made that kind of an arrangement to have someone else take over what Mr. Gregor was doing and have Mr. Gregor move the truck out of the way, but that's not how the facts actually unfolded. Again, just sort of to reiterate, Officer Kalunga, by his own testimony, said, I came over and I said, move the trucks out of the way. They're blocking these lanes. There was no back and forth about information, again, of, I understand there's priorities and let's work this out. Get your trucks out of here. Officer Flores overheard that, and there was no consultation by him either. He didn't say, okay, I heard Officer Kalunga talking to you, let's try to figure out how we can get this done. I'm worried about this. He said, move your truck. That's it.
Mr. Robinson asserts that the California Highway Patrol officers did not, quote-unquote, consult with the firefighters, including Mr. Gregoire, as required by the California statutes on accident scene management.
This is a very he said, she said case of all time.
Section 409.3 of the California Penal Code requires the law enforcement representative in charge of scene management to consult with representatives of other responding agencies,
important word
medical personnel who hold independent authority over patient care to ensure that all appropriate resources are properly utilized. Now, in this situation, rather than engaging in dialogue with Mr. Gregoire or any other medical personnel about the status of the patients or the necessity of the fire truck's position, the officers simply ordered the firefighters, including Mr. Gregoire, to move the truck while Mr. Gregoire was actively engaged in treating a patient. Accordingly, Mr. Robinson argued that issuing a unilateral order to remove equipment from an active rescue operation without any inquiry into the ongoing medical needs of the scene did not satisfy the consultation requirement of the statute.
Curiosity question: How did Flores know Gregoire was the guy that asked to move the truck?
He originally asked Captain Albright, who was also on the truck, whose truck is this? And Captain Albright said, well, it's our truck. And Mr. Gregoire is the driver. He's the engineer of the truck.
Okay, so it was established. Never mind.
Officer Flores then knew that Gregoire was the person to command to move the truck.
Okay, and what fire department was this? Which city? It wasn't San Diego, was it?
No, the city of Chula Vista. It's a city, South San Diego County.
It's a smaller city.
Correct, yes. This was outside the city of San Diego territorial bounds.
Counsel, could you at some point please address the excessive force issue? I wondered if you agreed with your colleague on the other side of the case that anytime there's an arrest, it's reasonable to handcuff somebody.
I don't agree with that, and I would challenge them to come up with something that says that's the case. There's nothing in the record, statements by anyone, declarations by experts, anything else like that, that would suggest that every time someone is arrested, they're put in handcuffs. I mean, I'm not an expert in police procedure myself, but that seems unreasonable to me. And again, I haven't seen anything in the record on this case that says that's the way the police normally operate. And in fact, Mr. Gregoire said, let's work this out. After Officer Flores said, I'm going to have to arrest you, Mr. Gregoire said, can't we just work this out? And Flores said, no, put the handcuffs on him and put him in the car.
Even worse.
I will note there was my colleague said something about the tightening of the handcuffs, and he referenced one section in the ER, but there's another section, 1.4.
How is that not an important piece to bring up? He literally, the guy who got arrested said, can we talk about this and figure it out? And then the guy said no and arrested him anyway. That's like literally preventing consultation.
40 to 141, this is the deposition of Mr. Gregoire, where he said, what did Officer Flores do
directly refusing to consult?
Him, if he could loosen the handcuffs, and Gregoire said he tightened them. That's page 140 of the ER. So there's clear testimony from Mr. Gregoire that he believed, at least from his perception, that the handcuffs were tightened. And we did cite several cases, if you want to talk about clearly established law, there's several cases that say tightening of handcuffs when it's not justified can qualify as excessive force. I don't think that's really a disputed point of law. I don't think you need a specific case that says if a police officer, CHP officer arrests a firefighter and tightens the handcuffs, that can be excessive force. I think you can extrapolate the general principle that that's going to be excessive force in this circumstance. So again, I don't agree with the idea that this is ordinary procedure, and I haven't seen anything because he wouldn't move his truck that suggests that it is.
And he didn't want to move his truck because he was attending to a patient. But also for some reason, both officers are like, oh, I didn't see a patient.
I'm getting short on time. So the one other aspect I wanted to very briefly address, the state has appealed all of the state law causes of action related to this claim as well. And as
I believe you also had to request to play body cam footage in the court, so they may not be using it. Guys, this isn't court. This is, like, I get the confusion. This isn't the court case. So, like, evidence isn't being presented right now. The motion to dismiss the case is being discussed. So, yeah, I mean, there might be body cam footage, and they might use that during court, but the cop's lawyer is trying to dismiss the civil case against him by the EMT who got arrested based on qualified immunity. This isn't the court case yet. The cop's lawyer is trying to get the court case to just not even happen based off of, like, benefit of the doubt, essentially. So they're arguing the nuances of benefit of the doubt for the police and how the ridiculousness of, like, how are you even going to give him benefit of the doubt? He arrested an EMT officer attending to a person, which is their job, on an emergency scene. So it's like, yeah, this is not the court case. They're not presenting evidence to the jury. There's no jury yet. There's not even, like, these judges are there to decide collectively if the court case should even happen at the request of the officer's lawyer. Which, yeah, like, what you can't just, like, motion to dismiss and have no reason. Like, you can motion to dismiss and then basically give them your reasoning, and then they can decide basically if it's worth arguing. Because, you can't just say, I motion to dismiss, and then this happens. Like, there has to be substantial enough of an argument to at least create a discussion like we're watching before you even get to try to do this. Like, you have to have some form of logic given before you even get to do this, basically.
As we've argued, I don't believe this court should exercise jurisdiction to consider those claims. This is an interlocutory appeal on qualified immunity. It's not an appeal after a final judgment where those things are generally going to be thought of. And the test for qualified immunity and the test for liability under the Bain Act, Civil Code 52.1, or assault and battery, things like that, are different. So resolving the qualified immunity issue doesn't resolve those particular claims. And so I would say, regardless of the outcome on that the court should remand the state law claims. So I believe, it looks like my time is about up. Again, on the qualified immunity, just to get back to the arrest very briefly, I believe the law is clear by statute. We don't need a case that's addressed this particular circumstance. I'll admit there isn't one, but the statute itself says that you have to do this consultation. Again, there may be some circumstances where that becomes confusing or an issue. This case is not one of them. There was no consultation at all. No consultation does not equal some consultation under any structure. So with that, I'll take a seat unless there are any questions.
Curiosity question.
Yes.
CHP is like a state police officer. They're the top guns.
Right.
And
correct.
Fire department was Chula Vista.
Yes, that's
They're the little guys.
They are the little guys.
So these are some big bad guy police officers. Use bad guy in the wrong context, I'm sure. They're the head honchos on this scene, so to speak, and that's the way they acted. From your perspective. Right.
Our perspective, yes, is correct. That Officer Flores basically marched on the scene. He didn't talk to Officer Colunga at all. They referenced this collective action.
Colunga CHP too?
Colunga CHP also, right. So Colunga gets there first. He tells a couple people to move their trucks, they do. He tells a couple more people to move their trucks, they don't. Flores overhears that. He marches on and says, get your trucks out of here. Doesn't talk to Colunga, doesn't ask them, what are you doing with the patients? How can we get this done? He overhears that, and he immediately takes command and says, move, get out, I'm in control. And that's the end. All right, so I'm going to take my seat.
I need my rope.
Mine is here. Mine is here.
Rebuttal.
You dispute his characterization
Of which part, Your Honor?
of the CHP being the big guys on the block and they acted like it?
I dispute, actually no. I think they do have a different set of interests. I think they do have a different perspective on the scene and the nature of the risk to passing motorists that a reasonable firefighter might have a different perspective on. I think that as between reasonable CHP officers, reasonable firefighters, I think they are going to look at it
different
in
jobs,
different ways.
different priorities.
Counsel referred a lot to disputed facts. We're not relying on disputed facts or disputed issues of fact.
So do you contend that Flores actually consulted with Gregor?
Not exactly. We're not saying that he consulted or didn't consult, because that would be a disputed issue of fact. What we're saying is based on the undisputed facts, that's fact 63, appellate record 59, fact 64, appellate record 59 also, that he overheard Officer Colunga talking to them.
Right. But doesn't he have a mandatory duty under that one statute that says he shall consult?
Yes. And what we're
Yes. Which is why this is semi-ridiculous, because it literally uses the word consult, not command, consult, discuss.
saying is
Don't you have to prove at trial that he consulted?
No, we don't, because it just
Yes,
has
you
to be
would.
clear to every
Yes, you
single
would.
reasonable officer beyond debate that that was not consultation to lose qualified immunity. Or stated differently, as long as a reasonable officer could think.
Could believe that that was consultation? Okay,
A
that's what you have to
command,
show.
a verbal
Yes.
command.
So we don't need to go to trial for
A
that.
reasonable
That's-
officer could think that ordering the firefighter to move the truck constituted consultation.
Yes, it would have to be beyond debate. And because we don't have a definition of consultation, it's not beyond
You
debate.
can't use the ordinary definition of consultation, just look at the dictionary.
She's like, are you fucking serious?
We use the ordinary definition, which is to seek information and advice from. Then Officer Flores overheard Officer Colunga asking the group why they had not yet moved their engine. So he's seeking advice from them, or not seeking advice, seeking information from them, which is the normal definition of consultation. So a reasonable officer could believe that was consultation, whether or not, as a factual matter at trial, that turned out to be consultation. So that's our point. And counsel admits there's no case on point here. Now, he says...
So I'm just curious, because Judge Gold said something that puts this sort of in a perspective for me, which is, look, you guys, your clients they're supposed to be cooperating at the scene of this accident to ensure the public safety and the health of the people involved in the accident. Why can't you guys just resolve this, settle this? I mean, it seems like you're spending a lot of money fighting this when, you're not fighting for some grand principle here. You're not opposed to each other, really.
Right, this
Bro,
is...
she really went, the fuck are we doing here?
So we quote Davis v. Scherer in the briefing, and Davis v. Scherer has a good answer to that question.
Does it?
And if I may quote, the officials are subject to a plethora of rules, often so voluminous, ambiguous, and contradictory, and in such flux that the officials can only comply with or enforce them selectively. In these circumstances, officials should not always err on the side of caution.
He's basically saying there's so much shit they're told to do and told to keep in mind that it's hard to say that they're going to be able to keep everything in mind. And if they keep too much in mind, they're not going to be able to do much. So they shouldn't be cautious. They should just do. That's what he's arguing.
These situations develop rapidly. It's happening at night. There's a lot of there's patient care going on. There's concern about what's going on in the freeway, and there isn't necessarily an opportunity to have the full, robust consultation we might want post hoc. So looking at the scope of discretion here, we just have to ask, could a reasonable officer, is it beyond debate that a reasonable officer could have taken these actions? Well, Yes, we have that situation because there's no case law in point, as they admit.
You don't want this because there'll be some case law on the point, do you?
So this court has discretion to decide the first prong issue as well. Under the first prong, because we say that a reasonable officer
maybe he shouldn't have saved his minutes for rebuttal. He's getting clowned on.
Could believe that consultation happened. That's all you need for probable cause is a reasonable belief. You don't have to be actually 100% accurate. A more prudential or more conservative way to handle this would be only under the second prong, because as the Supreme Court has warned, highly idiosyncratic factual circumstances do not always create the best law, do not always create the best rules.
Okay. Counsel, I have a question for you, and I guess my question would go to...
triple threat. Here it comes.
To your friend on the other side of the case as well. Is there any chance here that if we...
The 1, 2, 3 combo.
Deferred submission in the case temporarily to let both parties decide if they both wanted to mediate voluntarily, that this case could go away? In other words, would your office want us to give that option to the two parties, or would you prefer that the court gives you a ruling that says when there's a dispute between police and fire personnel, one side or the other wins?
Your Honor, we are always interested in taking advantage of ADR options when they may produce a result that's more efficient and in the interests of the people of the state of California. I have understood prior statements by counsel for Mr. Gregoire to state that they would not be interested in getting rid of this case unless there was a certain very public, very transparent sort of rulemaking activity. They may have changed their perspective on that. That's what we've understood from...
Judge Gold is talking about referring you to the Ninth Circuit Mediation Unit. Have you been contacted by them to mediate this case yet, or?
So I'm actually not sure factually the exact circumstances what happened with the mediation.
It's kind of like saying
the mediation
factually.
Procedure there. Because I came onto this case recently through a change in counsel, so I apologize for not knowing that, Your Honors. I will again state that we're always interested in ADR options.
I don't know if they contact the parties in every case or not, but your side would be interested in mediation, I'm hearing, if Gregoire was also interested.
Yes, Your Honor. And yes, so to be specific, deferring the decision here in favor of giving us an opportunity to mediate, yes, we would be interested. If that doesn't happen,
I don't think the guy making this case, I don't think the EMT officer is suing him for mediation. I don't think he's trying to be like, let's figure this one out, guys. let's fix this situation. This is a real mess. Let's make this easier for the other guys. No, I think he's like, fuck you, dude.
remain confident that they admit there's no case on point. There's no case on point that decides the second prong of the qualified immunity issue.
Okay, thank you.
Mr. Robinson, would you be interested in perhaps participating in mediation before our mediation unit?
I believe so, Your Honor. I'm perhaps not the right person to ask about that. I'm principally the appellant lawyer, but I do understand kind of how the case is proceeded. And it is my understanding...
That means he's not the lawyer in charge.
...that there may... I mean, I can't disclose too much in the way of settlement discussions. I understand there have been settlement discussions, and there may have actually been a mediation already. I'm not sure. It was our understanding that the case essentially was settled, and again, I don't want to represent something that may or may not be correct, but it's my belief, at least, that the CHP is the one that has pushed this appeal forward. We're always interested in settlement talks and trying to make this go away, and I think we've really tried to do that before having to go through all the briefing and everything else like that. I don't know what the appropriate process would be at this stage. But yes, I think we would be happy to accept deferred briefing or deferred ruling.
Counsel, I think the normal type of order.
So deferred ruling, they're basically saying, like, we don't need to go to court. We're happy to defer the ruling to the judges.
That we enter, in some cases, would be an order to the parties that would ask them to advise if they both wanted to mediate, or we'd have the mediation office contact the parties, and we'd say that submission was deferred until the parties had time to respond to that, and that if they wanted to mediate, then we'd defer submission until the conclusion of the mediation.
I believe that'd be absolutely appropriate, yes.
And then whenever we knew that it wasn't going to be mediated, then we'd proceed to develop and issue an opinion.
I don't think anyone in this room wants to waste money on a court case for such a nothing burger of a situation.
Your Honor, we would be open to that, certainly.
Okay.
All right. Thank you very much, counsel.
Thank you, Your Honors.
Gregor versus CHP and Flores is submitted, and this session of the court is adjourned for today. Thank you both.
Following this oral argument, the case was referred to mediation, which is a process in which a neutral third party assists the parties in reaching a voluntary settlement. A Ninth Circuit mediator was assigned to schedule a conference to explore whether the parties could resolve the issues in dispute without the court issuing a decision on the appeal. And on June 14, 2018, the case was dismissed after the parties reached an undisclosed settlement, bringing the litigation to a close without a ruling from the Ninth Circuit on the qualified immunity question. The resolution of this case through mediation rather than an appellate decision offers a useful lens through which to examine the role of alternative dispute resolution in the court system. Mediation and other forms of alternative dispute resolution can serve as efficient and practical tools for resolving litigation, saving the parties from the time, expense, and uncertainty of continued court.
What is this video?
Proceedings.
Oh, yeah, sorry, I'm also here.
Parties ultimately determined that a negotiated settlement would serve their interests better than awaiting a decision from the Ninth Circuit. However, the efficiency of that resolution has consequences beyond the parties themselves. Yeah. Because the court never issued a ruling on Officer Flores's qualified immunity argument, the legal questions at the center of this appeal, including what level of quote-unquote consultation is required between law enforcement and emergency medical personnel on the scene of an accident, remain unresolved as a matter of binding precedent for future litigants facing similar.
So, yeah, I mean, I'm going to say what he's about to say, I guess, so I can feel involved. He's saying because they solved it outside of the court, there isn't going to be something to go off of for somebody if this were to happen again, which was the entire argument of him being like, there's nothing to go off of. What was he supposed to do?
Disputes at the
intersection. And he wasn't saying whether he was correct or not. He was just saying that there was nothing.
Patients by emergency medical personnel. The absence of a judicial ruling means that the governing legal framework in this area continues to lack the clarity that only appellate decision making can provide. This case demonstrates an ongoing tension in the legal system, as the out-of-court resolution of individual disputes, while often the most favorable outcome for the parties involved, can leave unresolved the broader legal questions that courts alone have the authority to definitively answer.
Which can continue to circle and make, which could continue to endlessly cycle certain situations if there's never an actual legal precedent set or like anything. I mean, guys, like Supreme Court stuff, like it's not like the Supreme Court is like, I declare thing, like it's basically the Supreme Court laws are based off of the rulings of cases they're given, like, and that goes down all the way to judicial, civil, like statewide, everything. Like the rules of court and the arguments of court are established based off of previous rulings and findings of other cases. Like it's not like they just decide like officers don't do that. It's like they are given a case that is taken to court and they come to a decision. Therefore, later situations that are similar or parallel to that situation, that's the rules. That's what's to be assumed.
Courtroom interaction that you'd like us to explore in the comments below. Thank you for watching, and don't forget to like and subscribe so we can help foster a more informed society.
Oh shit, I clicked a new one. Whoops. Anyway, yeah, very interesting. I mean, I really like this channel. I know this isn't like the flashy, weird, crazy body cam footage that a lot of people love to watch, but I think it's a very interesting lens into the legal system because, yeah, I get it makes sense why they would want to settle it out of court because, like, this shit takes forever. It's a huge issue with the American legal system is it's so slow and so backed up that this shit takes years. They settled it out of court a year after this. This started in 17. They settled it in 18. Like that. And that's the efficient option. That's the efficient option. So it's an interesting lens into the speed and inefficiency that the American court and legal system operates at. And I think it was a really cool insight in like the cleverness of a lawyer, because it's like it's really hard for a lot of you when you hear a defense lawyer defend a murderer, right? Like that's tough to hear, but legally that's his job. That's what he's supposed to do. But when you see a defense lawyer argue so well over something that isn't as deadly or ghastly, it's a very interesting thing to see because you sort of get the point of what they're there for without feeling so enraged by the fact that they're defending a serial killer or a murderer or a thief, etc., right? I think it was really interesting because, like, yeah, the argument from both lawyers is substantial to me from my perspective because it makes sense. Like, there wasn't technically stuff to establish what he was meant to do, but also there was, but also it's ridiculous that he would arrest somebody doing that, arrest an EMT giving medical care to a person on the scene. Like there's a levels of intricacy and complexities that I can see why both lawyers make their arguments. I thought it was very cool. I mean, maybe I'm just a little like legal system nerd, but I would love to hear what like you guys think. I'd love to hear what YouTube thinks. I thought this one was great. This one was a nice little switch up.